When we think about security in the physical world, the mechanics of it are just beautifully simple. You buy a heavy solid oak door,
Right, exactly.
you install a steel deadbolt, you turn the key, you hear that satisfying click, and you know you are secure. Your privacy is defined by physical boundaries. If someone wants to listen to your conversations, they have to physically cross a line.
Yeah, they have to press a glass against that door or pick the lock or, I don't know, shatter a window.
Exactly. It's an undeniable visible intrusion. It leaves a literal mark.
Right, because the breach of a physical space, it basically forces a confrontation. You
Yeah.
see the broken glass, you see the splintered wood. The trespass is something you can actually point to and say, hey, my rights were violated in that exact spot.
But then we look at our digital lives, and that entire conceptual framework just completely collapses. I mean, there is no wooden door.
Not at all.
Your smartphone, your personal emails, your private WhatsApp messages, your location data, they are all just constantly moving through this series of invisible, frictionless digital corridors. If the state decides to listen in on your life, there's no broken lock.
Yeah, there is no shattered glass. The surveillance is entirely silent. It leaves absolutely no trace that anyone was ever there.
It's the ultimate invisible trespass. And the legal architecture that governs whether that trespass is, a lawful exercise of state power or an unlawful violation of your fundamental rights is easily one of the most complex, fiercely debated, and frankly precarious areas of modern jurisprudence.
It really is. And we are taking a massive, deeply explanatory journey into Indian cyber law today. Specifically, we're going to dismantle the legal architecture of surveillance, privacy, and evidence.
We've got a stack of incredibly detailed end semester study notes to get through today. We're covering constitutional doctrine, the old Colonial Telegraph Act, the Modern Information Technology Act, criminal procedures, landmark case laws, and the comprehensive CCG report on surveillance.
And we know exactly who is listening to this deep dive right now. You are a law student. You are staring down the barrel of a major exam.
Yeah, and you don't need a superficial skim of the syllabus. You need the actual mechanics of the law to stick in your brain. You need to understand the underlying legal reasoning, right? The subtle distinctions between highly similar statutes and those hidden exam traps that consistently catch people out.
Exactly. We are absolutely not going to just read these notes back to you like a table of contents. We're going to build the house from the ground up so you understand exactly how the plumbing works.
Okay, let's unpack this. We need to start with the absolute foundation. Because before we can understand how the government legally spies on its citizens, we have to understand the right they are actually infringing upon.
Right, because cyber law operates on this living, breathing battleground between state power and individual autonomy. And the fundamental right, caught in the crossfire, is privacy.
But the Indian Supreme Court's relationship with privacy is, it's essentially a story of a massive, decades-long historical flip-flop.
Oh, massive.
If we rewind to the early days of the Republic, the Constitution didn't explicitly protect privacy at all, did it?
No, it didn't. The Supreme Court's early approach was intensely literal. For decades, the dominant precedents were two major cases. That's MP Sharma versus Satish Chandra in 1954 and Karak Singh versus State of Uttar Pradesh in 1962.
And the facts of these cases are crucial for understanding the mindset of the judiciary at the time, right?
Absolutely. So in MP Sharma, the government launched these massive coordinated search and seizure operations across dozens of locations belonging to the Dalmia corporate group. They were looking for evidence of financial fraud.
Okay.
And the Dalmia Group argued that these aggressive, sweeping searches violated their fundamental rights. But the Supreme Court looked at the text of the Constitution and concluded that the framers had not explicitly written a right to privacy into the document.
Right, like they have the Fourth Amendment in the United States.
Exactly. Because it wasn't explicitly there in the Indian Constitution, the court basically refused to read it into the text.
I mean, I can almost understand that in a corporate financial context, white-collar crime. But Karak Singh was a completely different level of intrusion. The facts of that case are actually shocking when you view them through a modern lens.
They are wild. So Karak Singh dealt with a man who had been accused of dacoity, which is armed robbery, but he was released due to a lack of evidence.
He was released. He was free.
He was. But despite his release, the Uttar Pradesh police opened a history sheet on him. And this wasn't just passive observation from a distance. The police regulations allowed them to make domiciliary visits.
Which means what exactly?
This meant police officers would literally show up at Karak Singh's house in the middle of the night, bang on his door, wake him up from his sleep, and demand to know his whereabouts and activities. They would secretly picket his house and just constantly track his movements.
Wait, how does a court look at a police officer banging on a citizen's door at 2 a.m. without a warrant and not see a constitutional violation? I mean, exactly what was the legal justification for ignoring that intrusion?
Well, the majority of the judges in Karak Singh acknowledged that the secret picketing was bad, sure, but when it came to the broader concept of a right to privacy protecting him from these midnight visits, they just stuck to the MP Sharma logic.
They just said, it's not written down.
Exactly. They stated that the right to privacy is not a guaranteed right under our Constitution, and therefore the attempt to ascertain the movements of an individual is not an infringement of a fundamental right.
Wow.
This is a pretty bleak era for civil liberties. The literal interpretation of the text completely blinded the court to the reality of the oppression.
But society changed. Technology exploded. The nature of state power evolved dramatically. A literal reading of a 1950 text couldn't possibly survive the digital age. Which brings us to the watershed moment in Indian constitutional law.
Yes, the case that every single law student must be able to cite in their sleep.
Right. The 2017 case of K.S. Puttaswamy versus Union of India.
So the Puttaswamy case was actually born out of the challenge to the AHAR scheme, which is the government's massive biometric database.
Right, the fingerprint and iris scan database.
Exactly. The petitioners argued that the database violated their privacy. The government, relying on those old cases from the 50s and 60s, argued that citizens didn't even have a fundamental right to privacy in the first place.
Which is wild to say out loud in 2017.
It really is. So to resolve this massive contradiction, the Supreme Court convened a unanimous 9-judge bench. And the sheer size of that bench indicates the gravity of the constitutional crisis.
Because a 9-judge bench essentially exists to rewrite history.
And they did. They systematically dismantled the logic of MP Sharma and Karak Singh.
Right.
The 9 judges unanimously declared that the right to privacy is not merely a statutory right or some nice philosophical idea.
Right.
It is an intrinsic, inalienable part of the right to life and personal liberty guaranteed under Article 21 of the Constitution. They ruled that you cannot meaningfully exercise your right to liberty if the state can constantly peer over your shoulder.
One specific part of the Puttaswamy judgment really stands out in these study notes, especially regarding cyber law. Justice Sanjay Kishan Kaul wrote a concurring opinion that moved the conversation far beyond physical privacy, like keeping the cops out of your bedroom, and focused heavily on informational privacy.
Yeah, Justice Kaul's opinion is basically the bridge between the physical world and the digital world. He recognized that modern human existence leaves an inescapable digital footprint.
Right. Every website you visit.
Every location your phone pings, every digital transaction you make, it creates a mosaic of your life. Informational privacy, as he articulated it, is about decisional autonomy. It is the fundamental right to control the extent to which information about you is accessed, stored, and analyzed by others.
And he uses a very specific phrase that is absolute gold for an exam essay. He talks about the chilling effect. Let's break down what that actually means in practice, because it's not just a buzzword.
No, it's not. The chilling effect is a foundational concept in civil liberties jurisprudence. It describes a phenomenon where a law or a state action doesn't actually actively ban a specific behavior, but the mere threat or fear of state surveillance causes citizens to subconsciously alter their behavior and self-censor.
I see.
If you know or even suspect that the government is reading your emails or tracking your web searches, you will hesitate before researching a controversial political topic. You will think twice before attending a protest. You will reconsider reaching out to an investigative journalist.
Because the surveillance doesn't put you in physical handcuffs, it puts your mind in a psychological cage.
That's a great way to put it.
The notes bring up a really fascinating comparative law example to illustrate this, the U.S. Supreme Court case of NAACP versus Alabama from the 1950s. The civil rights movement is in full swing, and the state of Alabama, which was deeply hostile to civil rights, tried to force the NAACP to hand over its entire membership list.
Right. And the state of Alabama claimed they just needed the list for routine corporate registration purposes.
Sure they did.
Yeah, right. But the U.S. Supreme Court saw right through it. The court struck down the demand, ruling that compelling the disclosure of those names would expose the members to economic reprisal, loss of employment, and physical violence.
Obviously.
But more importantly, the court held that the mere knowledge of this exposure would induce a chilling effect. It would dissuade current members from staying and paralyze new members from joining. The surveillance itself was the weapon used to destroy the freedom of association.
But we didn't even really need to look to the US for that logic. We actually had it in India decades ago. The majority just ignored it. The notes mention Justice Subbarao.
Oh, Justice Subbarao was brilliant. He was the lone dissenting voice back in the 1962 Karak Singh case. While the majority was saying privacy didn't exist, Justice Subbarao wrote this powerful dissent, arguing that surveillance places psychological restraints on individuals.
He saw it 50 years early.
He really did. He argued that conditioning a person's mind with the constant anxiety of observation introduces inhibitions that are just as effective at destroying liberty as physical prison walls. It took over 50 years, but the Puttaswamy bench essentially elevated Subbarao's old, ignored dissent into the binding law of the land.
Okay, so we have established the constitutional bedrock. Privacy is a fundamental right under Article 21, and state surveillance inherently infringes upon it by creating a chilling effect.
Right.
But fundamental rights in India are not absolute. The state can restrict your right to free speech, your right to assemble, and yes, your right to privacy. The real question is, what is the legal hurdle the state has to clear to justify that restriction?
And this is the most critical doctrinal shift you must understand for your exam.
Mm.
Before Puttaswamy, the state had immense leeway. Post-Puttaswamy, to prove that a restriction on privacy is lawful, the state must pass a highly structured, rigorous test known as the proportionality test.
The proportionality test. This is the gauntlet every single surveillance law or wiretap order has to run through. The study guide lays out the specific formulation from the subsequent Aadhar judgment, heavily drawing on the work of legal scholar David Bilchetz. It's a 5-part test. Let's dig into the mechanics of each of these 5 steps.
Let's do it. So the first step is legality. The restriction on privacy must be sanctioned by a valid existing statute.
Okay.
The executive branch, like the police or intelligence agencies, they cannot just decide to surveil a citizen based on an internal memo or a departmental policy. There must be a specific law passed by the legislature that clearly authorizes the intrusion.
Okay, so you need a law on the books. Check. Step 2 is legitimate aim.
Right. The law must have a proper, constitutionally valid purpose. The government cannot restrict privacy for arbitrary reasons. Surveilling a political rival to win an election is not a legitimate aim.
Obviously not.
The aim must be tied to compelling state interests,
Uh-huh.
such as safeguarding national security, maintaining public order, or preventing a serious crime.
Step 3 is sustainability, which is sometimes referred to as suitability or the rational nexus test.
This step asks, is the measure actually capable of achieving the legitimate aim? There must be a logical connection between the surveillance and the goal.
Can you give an example?
Sure. If the police are trying to dismantle a sophisticated online financial syndicate, is placing a physical wiretap on the local bakery's landline a suitable way to achieve that? No, the measure lacks a rational nexus to the objective.
Makes sense. Step 4 is necessity. And this feels like the highest hurdle.
It is definitely supposed to be. The necessity prong demands that the measure must be the least rights-restrictive option available to the state. The court must ask, are there alternative methods the government could have utilized that would be less intrusive to the citizen's privacy, but equally effective at achieving the goal?
So if the state can get the information they need by subpoenaing a bank record, they cannot legally justify placing a 247 hidden camera in the suspect's living room.
Exactly. The intrusion must be absolutely necessary, not just convenient for the police.
And finally, step 5 is balancing.
Balancing is the macro-level view. Even if the law is legal, has a legitimate aim, is suitable, and is necessary, the court must weigh the competing interests.
The big picture.
Right. Does the measure have a disproportionate impact on the rights holders? Do the harms inflicted on a democratic society's civil liberties outweigh the concrete benefits gained by the state security apparatus?
So if a law requires monitoring the private emails of 1 billion people just to potentially catch 10 tax evaders, it completely fails the balancing test.
Absolutely.
Let's try to anchor this 5-part Aadhar proportionality test in your mind with an analogy. Let's imagine the state is a doctor, the societal problem like terrorism or crime is a severe disease, and surveillance is an incredibly aggressive experimental medical treatment.
I like that. Let's test that analogy against the 5 prongs.
First, legality. Has this experimental drug actually been approved by the medical board, or did the doctor just mix it up in their sink? The treatment must be authorized by law. Second, legitimate aim. Is the doctor prescribing this harsh drug to actually target the disease, or are they just giving it to the patient for a completely unrelated, improper reason?
Exactly.
Third, sustainability. Will this specific chemical compound actually cure this specific disease? Does the drug fundamentally work?
Yeah, does it have a rational nexus?
Fourth, necessity. Is there a milder drug, perhaps a simple antibiotic, that would cure the infection just as effectively without the severe side effects? You don't use chemotherapy if an aspirin will do the job.
The least restrictive option.
And fifth, balancing. Even if the drug works, are the side effects so catastrophic that they kill the patient while trying to cure the cold? Does the cure destroy the body?
That doctor analogy works very well for structuring an essay answer. Legality, aim, sustainability, necessity, balancing. But I have to give you a massive warning right here.
Uh-oh, exam trap alert.
Yes. When you are writing your exam, you cannot just list these 5 steps and pretend the Indian legal system works perfectly. You must demonstrate an understanding of how courts actually apply this test in reality, particularly the 4th prong, necessity.
The study notes actually reference a study by legal scholar Aparna Chandra regarding exactly this. Why does the necessity prong fail in practice?
So Aparna Chandra conducted a comprehensive empirical study analyzing Supreme Court jurisprudence over a 12-year period from 2004 to 2016. And she found a deeply concerning pattern. While the Supreme Court loves to cite the theory of proportionality, they rarely, if ever, engage deeply in this strict necessity analysis.
Wait, they just skip the 4th step?
They don't skip it, they dilute it. Instead of forcing the government to strictly prove that there were absolutely no less rights-infringing alternatives available, the courts exhibit extreme deference to the executive branch.
Oh, I see.
If the government submits an affidavit saying, hey, this surveillance was necessary for national security, the courts often just accept that claim at face value. They defer to the government's operational judgment.
So while the Bilchitz formulation is the beautiful theoretical standard you must memorize, you will score much higher on an exam if you also point out that judicial practice frequently fails to hold the state's feet to the fire on the least restrictive means test.
Exactly. The theory demands strict scrutiny, but the reality often defaults to executive deference. That is a brilliant nuance to add to your exam.
Okay, we understand the constitutional standard now. We know the government has the power to restrict privacy, provided they have a valid law. So let's look at the actual tools the government uses to break into the digital house. Let's look at the oldest law still on the books, a law drafted during the British Raj, before the internet, before mobile phones, before the concept of digital data even existed.
The Indian Telegraph Act of 1885.
1885. The fact that a colonial-era statute still governs a massive percentage of modern telecommunications interception in India is just staggering.
It really is.
Yeah.
And to understand how a law built for brass tapping keys applies to an iPhone, you have to look at the statutory definition of the word telegraph in Section 3 of the Act.
Because when I hear telegraph, I literally picture a guy in a train station in 1890 tapping out Morse code. How does that apply to my modern life?
Well, the colonial drafters used incredibly expansive language to future-proof the law. The Act defines a telegraph as any appliance, instrument, material, or apparatus used for the transmission or reception of signs, signals, images, or sounds by wire or wireless means.
Ah, wireless means, that's the hook.
Exactly. Because of that open-ended phrasing, a modern 5G-enabled smartphone transmitting digital packets of voice data through the air falls squarely under this 1885 definition. Your phone is a telegraph. Therefore, the government's power to tap your phone is governed by Section 5, subsection 2 of the Telegraph Act.
Section 5.2. This is the power to intercept messages. But considering this law was written by an absolute colonial power, I'd expect it to be a blank check for surveillance. Surprisingly, the text actually sets a very high bar.
It does. The conditions in Section 5.2 form the absolute core of targeted surveillance jurisprudence in India. There are 2 distinct, substantive preconditions that must be satisfied before the government can legally place a wiretap.
Okay, what's the first one?
The first precondition is the threshold trigger. The government cannot intercept a communication unless there is an occurrence of a public emergency, or it is in the interest of public safety.
Let's pause on those terms. Public emergency and public safety, those do not sound like everyday occurrences. If someone steals my car, that is a crime, sure. But it isn't a public emergency.
You've hit on the exact tension. The Supreme Court clarified the gravity of these terms in the landmark 1997 case, PUCL versus Union of India.
This was the People's Union for Civil Liberties case? What was the context for that?
So in the 1990s, India was rocked by these massive political wiretapping scandals. A prominent politician discovered his phones, and the phones of his associates were being systematically tapped by the government. The PUCL filed a public interest litigation challenging the constitutional validity of Section 5(2), arguing it was being wildly abused for political espionage.
And what did the court say?
Well, in its judgment, the Supreme Court refused to strike down the law, but it heavily restricted how it could be used. The court explicitly defined public emergency as a sudden, unforeseen condition or state of affairs that affects the people at large and calls for immediate action. Similarly, public safety was defined as the state or condition of freedom from danger for the people at large.
The people at large. That phrase is doing a lot of heavy lifting. It implies a widespread threat to society as a whole, not just an isolated criminal incident.
It fundamentally limits the scope of the act. And the most perfect illustration of this limitation in action is a masterclass case from the Bombay High Court, Vinit Kumar versus CBI.
Walk us through the facts of Vinit Kumar. Why is it so important for the exam?
In this case, the Central Bureau of Investigation, which is India's premier investigating agency, suspected a public servant of engaging in corruption and accepting bribes. To gather evidence, the CBI obtained orders under the Telegraph Act to tap the official's phone lines. Their justification was that corruption is a menace to society, and therefore tapping his phone was in the interest of public safety.
Okay, bribery is undoubtedly a serious crime. It harms the nation. But does it meet the threshold of a public emergency?
The Bombay High Court looked at the CBI's argument and totally dismantled it. The court stated that while corruption is a serious offense, a corrupt official taking a bribe in a specific instance does not constitute a public emergency. It does not suddenly threaten the safety of the people at large.
Interesting.
Yeah, the court ruled that you cannot dilute the strict preconditions of the Telegraph Act to investigate routine criminal offenses where no broader immediate threat to the public exists. The threshold was not met, and therefore the wiretaps were entirely illegal.
This logic connects directly to another crucial legal distinction highlighted in the CCG report: the difference between law and order and public order, as established in cases like Ramlila Maidan.
Yes. The Supreme Court has drawn a very sharp concentric circle around these concepts. A simple law and order problem might be two people getting into a violent fistfight in an alleyway, or even a sophisticated jewel heist. It is a crime, it affects specific individuals, but society basically continues functioning.
Right.
Public order, on the other hand, is an aggravated form of disturbance. It affects the general, even tempo of the life of the community. A large-scale communal riot or a coordinated terrorist attack on a train station disrupts public order. The Telegraph Act can only be invoked for the latter, for threats to public order, not for localized law and order problems.
Okay, so the first precondition is the massive threshold, a public emergency or a threat to public safety. If and only if that trigger is met, what is the second precondition under Section 5(2)?
Once the emergency is established, the state must then prove that the interception is necessary or expedient in the interests of specific enumerated high-level grounds. These grounds are the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, or preventing incitement to the commission of an offense.
So a foreign military invasion triggers the emergency, and tapping the spy's phones is necessary for the security of the state. It's a two-step lock. On paper, it sounds incredibly robust.
On paper, yeah.
But going back to that 1997 PUCL case, the Supreme Court realized a massive flaw. The text of the law was strict, but the execution was a black box. There were absolutely no procedures to stop a rogue police officer from just bribing a telecom worker to tap a line in secret.
Exactly. The court realized that substantive law without procedural safeguards is meaningless. In PCL, the Supreme Court took the extraordinary step of laying down detailed procedural guidelines to regulate how these wiretaps are authorized. And in 1999, the executive branch finally codified those court guidelines into the Indian Telegraph Rules, creating what is now the famous Rule 419A.
Rule 419A. This is the bureaucratic machinery of surveillance. If you are a law student, you will be referencing this rule constantly. Let's break down the actual safeguards it created. How does a wiretap order actually get signed?
It cannot be signed by a local police inspector or a low-ranking intelligence officer. Under Rule 419A, an interception order must ordinarily be issued by a very specific, competent authority. At the central government level, that authority is the Secretary to the Ministry of Home Affairs.
The Home Secretary.
Right. And at the state level, it is the Secretary of the State Home Department. These are the highest-ranking bureaucratic executive officers in the government. The logic was that elevating the authorization to the highest levels of government would introduce accountability and prevent frivolous local abuse.
Does an order last forever? Like, if the Home Secretary signs it, can the police just listen to me for the rest of my life?
No, time limits are a critical safeguard here. Once an order is issued, it is valid for a maximum period of 60 days. The agency can apply for renewals, but the absolute hard maximum period for interception under one specific set of orders is 180 days. After that, the tap must end.
What about the data? Let's say the police listen for 60 days, realize I'm completely innocent, and close the case. Do they just file those recordings of my private conversations away in a permanent database somewhere?
Rule 419A explicitly mandates the destruction of records. The intercepted messages, the transcripts, and the interception directions themselves must be destroyed by the authorities every 6 months.
Oh, wow.
Yet, the only exception is if those specific recordings are required for the functional requirements of an ongoing prosecution. If you are innocent, the data must be purged.
But there's a practical gap here. The Home Secretary signs a piece of paper, but the Home Secretary doesn't physically climb up a telephone pole and splice a wire. They hand the order to the telecom service providers. The TSPs, these are private corporations, Airtel, Jio, Vodafone.
Right.
When a private corporation receives an interception order from the government, do they just blindly execute it? Are they just passive conduits?
They used to be, until a massive scandal forced the Supreme Court to intervene. This brings us to the 2011 case of Amar Singh versus Union of India. Amar Singh, a very prominent political figure, had his phones tapped. And when the case went to court, an incredible discovery was made. The interception orders that were sent to the private telecom company, Reliance Infocom, were blatant forgeries.
Wait, forged by who?
People trying to spy on him. They were completely falsified documents riddled with obvious grammatical errors, incorrect official designations, and fake signatures.
And the multi-billion-dollar telecom company just looked at a forged, misspelled document and handed over a politician's private phone calls.
They waved it right through.
Yeah.
They argued that they were just private companies following government instructions and couldn't be expected to act as investigators. But the Supreme Court came down on them like a ton of bricks.
As they should.
The court ruled that TSPs are not just private businesses. They perform a function of a public nature because they control the citizenry's communication infrastructure. Therefore, they have an inherent legal duty to act carefully and with a sense of responsibility.
That makes total sense.
The court mandated that TSPs cannot blindly execute orders. They must verify the authenticity of the interception orders to prevent unauthorized or forged tapping. They're essentially a vital, independent checkpoint in the surveillance apparatus. And as a direct result of this case, Rule 419A was amended to require secure, encrypted electronic communication of orders and regular mandatory authenticity checks every 15 days.
Okay, let's summarize the Telegraph Act before we move on. It is incredibly broad, covering all modern phones. However, it requires an extremely high threshold, a public emergency or a threat to public safety. The orders must come from the Home Secretary. They expire after 60 days. The data must be destroyed, and the telecom companies have a fiduciary duty to verify the paperwork.
That's the perfect summary.
Oh, hold on. Let me ask the obvious question. If the Telegraph Act requires a massive riot-level public emergency to justify a wiretap, how did the police investigate a sophisticated, multi-million-dollar corporate fraud or a serial killer or a drug smuggling ring?
Exactly.
Those are serious crimes, but they are not public emergencies. If the Telegraph Act is useless for routine law enforcement, and the CBI lost the Vinit Kumar case because bribery isn't an emergency, what tool does the government actually use?
You've just identified the exact institutional panic that hit the government in the late 1990s. The state realized that the Telegraph Act, heavily restricted by the Supreme Court and PUCL, was far too difficult to use for day-to-day law enforcement.
Right.
Furthermore, the Telegraph Act was conceptually designed for data in transit-like,
You sure?
a phone call happening in real time. But as the internet arrived, a new problem emerged. What about data that is simply stored? How do you intercept an email that is just sitting on a hard drive?
Ah, I see.
To solve these two massive problems, the high threshold and the issue of stored digital data, the government needed an entirely new statutory weapon. Enter the Information Technology Act of 2000.
The IT Act. This is the true architecture of the modern digital frontier in India. Let's start with the definitions, just like we did with the Telegraph Act. What is the digital equivalent of a telegraph?
The IT Act revolves around the term computer resource. The Act defines a computer resource to include computers, computer systems, computer networks, data, and computer databases. The profound difference here is that while a telegraph implies the active transmission of a signal, a computer resource encompasses data in all its states. It covers the data actively being transmitted over a network, yes. But crucially, it also covers data that is statically stored. It covers the archived emails in your Gmail account, the unread messages on your phone, and the encrypted files sitting on your laptop's hard drive.
So a smartphone is essentially a legal chameleon. When it is transmitting a voice call over a cellular network, it is a telegraph under the 1885 Act. But because it contains a processor and stores data locally, it is simultaneously a computer resource under the IT Act.
Yes. The police can choose which legal framework to use, and frankly, they are going to choose the IT Act every time because the powers granted under it are staggering. Let's examine the two massive surveillance provisions, Section 69 and Section 69B.
It is absolutely vital for a law student to keep these two sections strictly separated in their minds because they do very different things.
Very different. Section 69 deals with the interception, monitoring, and decryption of content. It gives the government the power to read the actual words you are typing, listen to the specific audio of your calls, and demand the decryption keys to your private files.
Wow. Okay, and what about 69B?
Section 69B, on the other hand, deals with the monitoring and collecting of traffic data or metadata.
I think we need a really clear analogy here to ensure you, the listener, fully grasps the difference between content and metadata in a digital context.
Go for it.
Let's use the concept of a digital shadow. Section 69, content interception, is the government looking directly at your face. They can see exactly who you are. They can hear the exact words coming out of your mouth. They know precisely what you are saying.
I like that.
Section 69B, metadata collection, is the government looking only at your shadow. They can't see your face, and they can't hear your words. But by tracking the shadow, they know exactly what time you left your house. They know you stood next to the shadow of a criminal defense attorney for 45 minutes. They know your shadow moved to a medical clinic specializing in oncology. They don't know the content of the conversations, but they know the exact pattern of your existence.
That digital shadow analogy is excellent because it highlights how revealing metadata truly is. But before we dive into the dangers of metadata, let's focus on Section 69, the content interception power.
Let's do it.
How does Section 69 of the IT Act differ from Section 5(2) of the Telegraph Act? This is where the expansion of state power becomes truly apparent. Remember the massive hurdles in the Telegraph Act, the requirement to prove a public emergency or a threat to public safety.
Yes, the hurdles that protected the public servant in the Vinit Kumar case.
Under Section 69 of the IT Act, those hurdles have been entirely eradicated. The requirement for a public emergency or interest of public safety is completely absent from the text.
They just deleted the threshold. So what replaces it? What is the trigger?
Section 69 retains the high-level national security grounds like sovereignty, integrity, defense of India, but it adds a deceptively simple new ground. It allows interception for the investigation of any offense.
Investigation of any offense. That is incredibly broad. Does that mean any crime whatsoever?
In practice, it means any cognizable offense. Think about the magnitude of this shift. Under the Telegraph Act, the state had to prove a catastrophic threat to the public at large to justify wiretapping a citizen. Under the IT Act, the state can authorize the deepest possible digital intrusion, reading your emails, decrypting your files for routine, day-to-day law enforcement against a single individual.
That's terrifying.
The high constitutional threshold that the Supreme Court explicitly relied upon in the PUCL case to justify the very existence of the Telegraph Act is entirely missing from the IT Act. The barrier to entry for state surveillance was fundamentally lowered for the digital age.
But surely there are procedural safeguards. Do they at least use the same Rule 419A bureaucracy?
Procedurally, yes. In 2009, the government issued the IT rules for interception. These rules largely mirror the Telegraph rules. The competent authority is still the Home Secretary, the 60-day time limits apply, and the destruction of data rules are present.
Okay, that's something at least.
But the crucial point for an exam is that while the procedure is similar, the substantive grounds to trigger that procedure are vastly wider and easier for the state to satisfy under the IT Act.
Let's pivot to a deeply controversial area within the IT Act framework. The government doesn't just tap wires anymore. They actively compel private technology companies to act as their surveillance proxies. This brings us to the explosive legal battle over intermediary liability and the concept of the first originator. Let's look at Rule 4.2 of the 2021 Information Technology Intermediary Guidelines.
This is a masterclass in the collision between legal mandates and mathematical reality. Rule 4.2 mandates that significant social media intermediaries that provide primarily messaging services platforms like WhatsApp, Signal, or Telegram must be legally capable of identifying the first originator of information on their platform if ordered by a court or by the government under Section 69.
The government's logic seems straightforward on the surface, honestly. If a highly dangerous, digitally manipulated deepfake video is causing riots across the country, the government wants to track the forwarded messages backward to find the specific individual who originally uploaded and sent the very first message. They want the digital ground zero.
The intention is law enforcement, sure. The problem is the architecture of end-to-end encryption. WhatsApp immediately sued the Indian government over this rule, and the technical arguments are fascinating.
Because it breaks the system.
Right.
Right.
End-to-end encryption means that the message is locked on the sender's device and can only be unlocked by the recipient's device. WhatsApp, the company, does not possess the keys. They cannot see the content of the messages, nor do they maintain a persistent, searchable database, mapping exactly who forwarded what message to whom.
Because if they did maintain that database, it wouldn't be a private encrypted system. It would be a surveillance system.
Precisely. WhatsApp argues that in order to comply with the first originator mandate, they would have to fundamentally re-architect their entire platform. They would have to attach a permanent traceable identity tag, like a digital fingerprint, to every single message sent by every single user, simply on the off chance that the government might ask for the origin of one specific message years down the line.
That's insane.
WhatsApp's legal argument is that this mandate breaks end-to-end encryption for everyone, fundamentally violating the Putsaswamy right to privacy by imposing a permanent, universal surveillance architecture that presumes the potential criminality of an entire population of hundreds of millions of users.
Wow.
The state says we need a backdoor to catch criminals. The technologists say a backdoor for the police is a backdoor for hackers, foreign intelligence, and authoritarian abuse. You cannot break encryption selectively.
That litigation is one of the most consequential privacy battles happening globally.
Now, before we leave the IT Act, let's jump back to Section 69B, the digital shadow. The collection of metadata. Now, a listener might hear this and think, well, they aren't reading my personal messages. They just know I sent an email. Who cares about metadata? It's harmless.
If you write that in an exam, you will lose marks immediately. Do not ever make the assumption that metadata is less invasive than content. In fact, you should explicitly cite the United Nations Human Rights Council principle regarding metadata, which was approvingly cited by Justice Nariman in the Putsaswamy judgment itself.
Why is the UN so terrified of metadata?
Because metadata allows for automated algorithmic profiling at a scale that content interception simply cannot match. Reading a suspect's emails requires human hours and context. Metadata is machine-readable instantly.
That makes sense.
The UN report pointed out that the aggregation of communications metadata can create an astonishingly comprehensive, intimately detailed profile of an individual's life. Think back to your shadow analogy. If the government collects metadata showing that a citizen called a suicide prevention hotline at 2 a.m., then browsed the website of an insolvency lawyer at 9 a.m., then pinged a GPS location at a psychiatric clinic at noon, the government does not need to hear a single spoken word of those conversations to know exactly what is happening in that citizen's life.
That is a staggering realization. The shadow tells a clearer story than the face.
It really does. Metadata reveals your medical conditions, your political affiliations, your sexual orientation, your financial distress, and your exact social network. It is arguably more dangerous than content because it is easier to collect in bulk, easier to analyze with AI, and reveals behavioral patterns the citizen might not even be consciously aware of.
And under Section 69B, the government can collect this incredibly sensitive traffic data simply to enhance cybersecurity or prevent computer contaminants terms that are defined so broadly they could cover almost any digital investigation.
Absolutely.
All right, let's take a step back. We've exhaustively covered the Telegraph Act and the IT Act, but let's look at the reality of a local police station. Both of these massive acts require an immense amount of bureaucratic red tape. You need to draft a complex application, send it up the chain of command, get the Home Secretary of the entire state to physically sign off on it, and then deal with review committees looking over your shoulder.
It's a lot of work.
If you are a local investigating officer, a station house officer dealing with a massive caseload, do you really have the time or the political capital to jump through all those executive hoops just to get the email logs of a local scammer?
Probably not.
Which brings us to alternative avenues. The reality of criminal procedure. Are there faster, easier ways for the police to get your data without using the IT Act?
Yes, there are. And this is where the theoretical elegance of cyber law crashes into the gritty, pragmatic reality of the Code of Criminal Procedure. Let's talk about the investigator's ultimate workaround, Section 91 of the CRPC.
Section 91. I've heard this called the blank check of local law enforcement. How exactly does it operate?
So Section 91 grants a remarkably broad power. It allows a court or an officer in charge of a police station, which is a vastly lower rank than a home secretary, to issue a written summons to any person, requiring them to produce a document or a thing that the officer considers necessary or desirable for the purposes of an ongoing investigation.
A document or a thing. In 1973, when the COPC was written, that meant a paper ledger or a bloody shirt. But in the digital age,
In the digital age, a document or a thing is interpreted to include electronic records. It includes server logs, IP address histories, subscriber information, and stored emails.
so an investigating officer in a local precinct can simply draft a Section 91 summons on their own authority, sign it, and email it directly to the legal compliance team at Google, Facebook, or a local internet service provider, demanding the user data of a suspect.
That's exactly what happens.
Wait, let me get this straight. No Home Secretary approval, no 60-day expiry limit, no Executive Review Committee verifying the proportionality.
None of it. It bypasses the entire Rule 409A safeguard architecture. It is a direct unilateral demand for data from a police officer to a tech company.
If the police can just use Section 91 of the CRPC to get my entire digital history from Google in 10 minutes, what is the point of the IT Act? Why does Section 69 even exist if this massive loophole is sitting right there?
That is the exact conceptual distinction you need to articulate in an exam. You have to differentiate between retrospective data and prospective data.
Ah, okay.
Section 91 is a tool for obtaining stored historical records from a third party. It is retrospective. The police are asking Google for emails you received last month, or asking an ISP for the IP addresses you logged in from yesterday.
And the IT Act.
The IT Act and the Telegraph Act are required for active, real-time, prospective wiretapping. You cannot use a Section 91 summons to order a telecom company to actively monitor a target's live phone calls and stream the audio to the police station for the next 2 months. Interception of an ongoing stream requires the high-level authorization of the IT or Telegraph Acts. But for gathering the massive trove of historical data we all leave behind, Section 91 is the path of least resistance.
But surely the courts have placed some limitations on a local cop's ability to just demand whatever they want. They can't just ask for everything.
The courts have established boundaries, yes. The primary limitation is that Section 91 cannot be used to conduct a roving or fishing inquiry.
What does a phishing inquiry look like in practice?
Well, imagine the police are investigating a cyber attack originating from a massive apartment complex with thousands of residents. They cannot send a Section 91 order to the ISP saying, hey, give us the entire internet browsing history of every single person living in this building for the last year so we can fish around and see if anyone looks suspicious.
That would be absurd.
Right. The courts have ruled that before issuing a Section 91 summons, the officer must have already formed a prima facie opinion that a specific document or record is genuinely necessary for a specific ongoing investigation. There must be a targeted nexus, not a broad dragnet.
Okay, that helps. We should also touch on how the state handles extraordinary crimes. The notes briefly mention MCOCA.
Yes, MCOCA stands for the Maharashtra Control of Organized Crime Act. It is a powerful state-level anti-terror and organized crime law that was initially enacted in Maharashtra and later extended to places like Delhi.
Why is it important here?
MCOCA is crucial because it possesses its own entirely separate sui generis legal framework for authorizing wiretaps, completely independent of the IT Act and the Telegraph Act. Under MCOCA, a police officer of the rank of superintendent can apply to the state home secretary for an interception order.
Is the threshold different?
Yes, they must show a probable cause of belief that a member of an organized crime syndicate is committing an offense, and crucially, they must demonstrate that normal, conventional intelligence gathering methods have either failed, are reasonably unlikely to succeed, or are too dangerous to attempt.
It's a specialized tool for taking down mafias and terror cells.
Yes, and interestingly, the Supreme Court upheld the constitutionality of MPOCA's surveillance provisions years ago. However, as the CCG report acutely notes, that constitutional blessing happened before the Puttaswamy judgment.
Oh, right. The 2017 shift.
Exactly. Whether MPO's procedures could survive the strict scrutiny of the modern five-pronged proportionality test, specifically the necessity and balancing prongs, is an open, highly debatable question in contemporary cyber law.
Before we leave the alternative avenues, there's one more deeply concerning mechanism in the notes. The Cyber Cafe rules of 2011. This feels like a relic, but the legal mechanism is fascinating.
It is a textbook example of indirect, frictionless surveillance. Under the Information Technology Guidelines for Cybercafe Rules, 2011, the owner of a cybercafe is legally obligated to comprehensively identify every single user.
What does that mean?
They must photograph the user, demand government ID, and maintain meticulous logs of exactly which computer terminal they used and what time they logged in and out.
But here's the surveillance hook. The rules state that authorized government officers have the power to enter the cybercafe and inspect these logs and user records at any time.
Yes.
Let me guess. They don't need a warrant.
No warrant, no Home Secretary approval, no need to demonstrate a public emergency. They don't even need reasonable suspicion that a specific crime has been committed. The infrastructure of surveillance is outsourced to the private business owner, and the state is granted frictionless, unrestricted access to the resulting database.
While the explosion of cheap mobile internet data in India has rendered physical cybercafes largely obsolete, the legal paradigm established by these rules, where the state mandates private entities to build surveillance databases that the state can access at will, remains a highly relevant concept.
Very relevant.
All right, let's take a deep breath. We have built the foundation, we know the laws, we know the loopholes. Now we enter the most dramatic phase of the legal journey.
The courtroom battle.
Exactly. Let's invent a hypothetical. A rogue police unit decides they don't care about the Telegraph Act, they don't care about the IT Act, they don't want to deal with the paperwork. They illegally hack your phone without any authorization, and they record a private conversation where you explicitly confess to a financial crime. You are arrested, indicted, and put on trial.
Okay, setting the stage.
The prosecutor stands up in court and tries to play that illegally obtained recording to the judge. The question is, can they use it? Does the illegality of the surveillance taint the evidence?
This is perhaps the most heavily litigated, intensely debated, and highly exam-relevant question in this entire syllabus. To understand the answer, we have to look at the traditional, historical Indian rule of evidence, which can be summarized in 3 brutal words: relevance over legality.
Relevance over legality. How does that practically operate in a courtroom?
Historically, Indian courts operated on a very pragmatic, arguably cynical principle. They fundamentally did not care how a piece of evidence was obtained. The only question the judge asked was whether the evidence was logically relevant to proving the crime.
Give me an example.
Imagine the police broke down your door without a search warrant, illegally ransack your home, and find a bloody knife hidden under your floorboards. That knife perfectly matches the murder weapon. Under the traditional Indian rule, the judge will admit the knife into evidence.
Even though they broke in illegally.
Yes. The police officer might face internal disciplinary action or a civil lawsuit for the illegal trespass, but the evidence against you is perfectly valid. The illegality of the search does not magically make the bloody knife irrelevant to the murder trial.
And this ruthless pragmatism applied to illegal wiretaps as well.
Absolutely. The Supreme Court affirmed this doctrine in major cases like R.M. Mulkani versus State of Maharashtra and Puran Mal versus Director of Inspection.
What happened in Puran Mal?
In the Puran Mal case, a Constitution bench explicitly declared that unless there is an express written statutory or constitutional provision demanding the exclusion of illegally obtained evidence, the court will not shut it out. The sole test of admissibility is relevancy.
Was there any caveat to that?
The only minor caveat introduced in Mulkani was that a judge retained a sliver of inherent discretion to exclude evidence if its admission would operate unfairly against the accused and destroy a fair trial. But as a general rule, illegal wiretaps were readily admitted.
Okay, but here comes the constitutional earthquake. The post-Puttaswamy shift. The rules of the game changed in 2017.
Exactly. The logic of Puran Mal and Mulkani rested on the old MP Sharma paradigm, the idea that privacy was not a constitutional right. If the police conducted an illegal wiretap, they were just breaking a procedural rule in a statute.
But Puttaswamy elevated privacy to a fundamental right under Article 21.
Right. Suddenly, an illegal wiretap is no longer just a procedural statutory error. It is a direct, violent breach of a fundamental constitutional right. The question then becomes, can a constitutional court turn a blind eye to a constitutional violation just to admit relevant evidence?
And this brings us to the clash of the case laws. If there is one specific conflict you must understand and memorize to ace this exam, it is the tension between the next 2 cases. Let's start with the Bombay High Court in 2019. We are back to Vinit Kumar versus CBI.
We discussed the facts of this case earlier. The CBI illegally tapped a public servant's phone while investigating a bribery charge. falsely claiming it was a public emergency. The Bombay High Court established that the wiretap was illegal. But the critical second half of the judgment was deciding what to do with the audio recordings.
Right, because historically, they would just admit them.
Applying the new post-Puttaswamy reality, the Bombay High Court took a radical step. They didn't just declare the evidence inadmissible, they ordered the CBI to physically destroy the recordings.
Ordering the destruction of relevant criminal evidence is a massive judicial intervention. What was their exact reasoning?
The court reasoned that if they allowed the CBI to use illegally intercepted messages to secure a conviction, they would be actively promoting contempt for the rule of law. It would send a horrific signal to the state.
They would say the ends justify the means.
Exactly. You would essentially tell law enforcement, hey, you can ignore the mandatory statutory rules, you can violate the Supreme Court's guidelines, you can trample on the fundamental constitutional right to privacy, and as long as your illegal actions manage to catch the criminal, the judicial system will reward you by admitting the evidence.
Which defeats the purpose of having the rules at all.
Right. The court stated that this ends, justify the means approach leads to manifest arbitrariness and destroys the very concept of a state governed by law. If there is no investigatory downside to breaking the law, if the evidence is always admitted anyway, the police will simply continue to break the law. Destroying the evidence is the only way to deter state overreach.
That is a powerful, principled stand. Vinit Kumar says illegal state wiretaps equal destroyed evidence to protect the Constitution. But then we look at the Delhi High Court in Deepti Kapoor versus Kunal Julka, a completely different approach. What were the facts there?
Deepti Kapoor was not a criminal case involving the state. It was a bitter, private marital dispute in a family court. A husband, suspecting his wife, secretly and illegally planted a recording device and captured a private conversation between his wife and her friend, where she was making highly derogatory statements about him and his family.
Oh, wow.
Yeah, he attempted to introduce this secret recording as evidence in their divorce proceedings. The wife, armed with a Puttaswamy judgment, argued that the secret recording was a gross violation of her fundamental right to privacy, and therefore, following the logic of cases like Vinit Kumar, the court must exclude it.
The recording is undoubtedly an invasion of privacy. What did the Delhi High Court rule?
The Delhi High Court allowed the evidence to be admitted. They acknowledged that the wife had a fundamental right to privacy. However, they ruled that in a courtroom, that right must yield to the opposite party's right to a fair trial, which includes the right to bring relevant evidence before the judge to prove their case.
So they went back to the old rule.
Basically, the court resurrected the old pour and mel doctrine, stating that as long as the evidence is relevant to the dispute, it is admissible, regardless of the privacy breach committed by the private citizen to obtain it.
Wait, I'm putting myself in the shoes of a law student taking an exam right now, and my head is spinning. One high court says you must destroy illegally obtained evidence because privacy is a fundamental constitutional right. Another high court says you must admit illegally obtained evidence because relevance is the ultimate king. How does a student reconcile these two completely contradictory rulings in a single essay answer? Is there a conceptual framework to organize this?
Yes, there is. And the brilliant, high-scoring way to reconcile these cases is by demonstrating an understanding of the difference between vertical privacy and horizontal privacy.
Vertical and horizontal. Explain that.
The Vinit Kumar is a textbook case of vertical privacy. It is the state, the massive institutional power of the CBI, violating the privacy of a solitary citizen. When the coercive apparatus of the state acts illegally, the constitutional protections are at their absolute zenith. The courts are willing to take the drastic step of throwing out relevant evidence to deter the government from acting like a tyrant.
And horizontal.
Deepti Kapoor, conversely, is a case of horizontal privacy. It is citizen versus citizen, husband versus wife. The state is not the entity that broke the law. The state is merely acting as the neutral arbiter in the courtroom. In civil disputes between private individuals, the courts prioritize giving both parties a fair, equitable chance to prove their respective cases. To achieve that fairness, they lean back toward the traditional relevance over legality rule.
Vertical privacy is state versus citizen, demanding strict deterrence. Horizontal privacy is citizen versus citizen, demanding a fair evidentiary playing field. That is a superb analytical framework.
It works perfectly.
Now, listening to the logic of Vinit Kumar, excluding evidence because the search was illegal, it sounds remarkably similar to a very famous doctrine in American constitutional law, the fruit of the poisonous tree. If the tree, the initial police search, is illegal and poisonous, then the fruit, the evidence gathered, is also poisonous and cannot be consumed by the court.
The parallels are exact. Historically, the Indian Supreme Court explicitly rejected the American fruit of the poisonous tree doctrine. We ate the poisonous fruit anyway, as long as it was relevant.
Right, poor and Mal.
But the Vinny Kumar case is a powerful indicator that post-Puttaswamy Indian jurisprudence is slowly, cautiously inching toward adopting that doctrine, at least in the vertical application of state-sponsored constitutional violations.
Before we close the book on evidence, we have to talk about the terrifying legislative exception to everything we just discussed.
Yeah.
We need to talk about the UAPA.
The Unlawful Activities Prevention Act. This is India's premier, incredibly stringent anti-terror legislation. And Section 46 of the UAPA creates a massive draconian carve-out regarding the admissibility of intercepted communications.
How does Section 46 bypass the normal rules?
Section 46 explicitly states that any evidence procured through the interception of communications under the Telegraph Act or the IT Act is automatically admissible in a UAPA trial, notwithstanding anything contained in the General Indian Evidence Act. The normal evidentiary protections are stripped away.
Is there any safeguard?
The only procedural requirement is that the accused must be given at least 10 days' notice of the interception order before the evidence is presented in the trial.
Okay, they get 10 days notice. They get to see the order. But the study notes highlight a massive, seemingly unfair kicker here regarding the application for that order.
And this is where the rights of the accused are severely curtailed. The accused is given a copy of the final interception order signed by the Home Secretary. However, they are not given a copy of the underlying application that the police submitted to the Home Secretary to justify the order in the first place.
Why does that matter?
Under previous iterations of anti-terror laws, like POTA, the accused got to see that underlying application. Why is that important? Because by reading the application, a defense lawyer could cross-reference the police's claims. They could argue, Your Honor, the police outright lied in this application to secure the Home Secretary's signature. The foundation of the wiretap is fraudulent, therefore the tap is illegal.
Oh.
Under the UAPA, the accused is blindfolded. They only see the final approved order. They do not see the underlying justification, which makes it mathematically near impossible for the defense to effectively challenge the legality or the proportionality of the wiretap in court.
The state holds all the cards, and the defense isn't even allowed to see the deck. All right, we are entering the final and perhaps most existential phase of this deep dive. Let's talk about the future.
Mass surveillance and reform.
Everything we've meticulously analyzed so far, from the thresholds in the Telegraph Act, to the metadata in the IT Act, to the local police using Section 91, to the UAPA, has fundamentally been about targeted surveillance. The police suspect John Doe of a crime, they generate paperwork, and they target John Doe's digital life. But the architecture of technology has evolved past the individual. What happens when the state decides that targeting individuals is too slow and instead automates surveillance on the entire population? Let's analyze CMS and NITRA.
This is the terrifying transition from retail surveillance to a wholesale industrialized surveillance. Let's start with the architecture of CMS, the centralized monitoring system. Approved by the government in 2011, CMS is a sprawling infrastructure project designed to automate the interception of mobile phones, landlines, and internet traffic across the nation.
To understand why CMS is so dangerous, we have to compare it to the old system. How does CMS alter the network flow we talked about earlier?
In the old targeted system, the government obtained a wiretap order and physically handed it to the telecom service provider, the TSP. The TSP's designated nodal officers manually executed the tap on their switches. Remember the Amar Singh forgery case. The TSP acted as a crucial, independent safeguard. They reviewed the paperwork, checked the authenticity, and could theoretically say, this order is illegal, we won't comply.
Right.
CMS is designed to ruthlessly eliminate that manual independent intervention. It establishes a direct, secure electronic bypass. It allows authorized intelligence agencies to directly provision target numbers into the telecom network on a near real-time basis.
So the intelligence officer just logs in and starts the tap.
Exactly. The intelligence officer sits at a terminal in a centralized data center and initiates the tap directly, without the TSP's nodal officers necessarily knowing or approving the specific target at that moment.
So the friction is gone. The independent entity outside the government who could act as a circuit breaker against illegal surveillance is completely cut out of the loop.
Precisely. By removing the TSPs from the operational execution, CMS removes transparency, nullifies the Amar Singh safeguard, and makes unauthorized or politically motivated surveillance exponentially harder to detect and stop.
And then moving from automated interception to active dragnetting, we have NITRA,
NITRA.
Network Traffic Analysis. Developed by a laboratory under the Defense Research and Development Organization, what does NITRA actually do?
NITRA is openly described as a dragnet surveillance system. It is designed to passively filter massive pipes of internet traffic in real time. It scans for predefined, suspicious keywords, words like bomb, terrorist, attack, or specific political phrases, across social media streams, blogs, public forums, and crucially, any unencrypted email or communication channels.
It's not looking for a person.
No, it doesn't target a specific suspect. It intercepts the global flow of internet traffic looking for algorithmic triggers.
It is essentially a giant digital vacuum cleaner, reading everything that isn't locked down by encryption, searching for red flags. Now, the CCG report included in the study materials heavily critiques these mass surveillance systems. If we apply the constitutional law we learned in the very first segment of this deep dive, how do systems like CMS and NITRA fare when pushed through the rigorous Puttaswamy proportionality test?
The report concludes that they fail spectacularly, specifically crumbling under the necessity and balancing prongs.
Why is that?
Well, subjecting the entire citizenry to dragnet keyword scanning or building an architecture that allows frictionless, unverified tapping is arguably not the least rights-restrictive option to find a handful of criminals. It reverses the presumption of innocence. It treats the entire population as suspects requiring constant monitoring. It is inherently fundamentally disproportionate.
That makes total sense.
Furthermore, the systems expose the absolute farce of the existing oversight mechanism. We need to do some math regarding the review committee mandated under Rule 419A.
Right, the committee of 3 high-level executive officials who are legally required to review every single interception order to ensure it was lawful.
In 2011, data obtained under the Right to Information Act revealed a staggering statistic. The central government alone was issuing between 7,500 and 9,000 interception orders every single month.
Oh my God.
And under the law, the review committee is only mandated to meet once every 2 months.
Let's run those numbers. 9,000 orders a month. That is 18,000 highly complex intelligence warrants that pile up every 2 months. If this committee meets for, let's be generous, 3 full days every 2 months, they would have to thoroughly review, debate, and verify the legal proportionality of thousands of complex intelligence dossiers per day.
It is a mathematical and physical impossibility. The Justice Krishna Committee report on data protection explicitly called this oversight mechanism unrealistic. It is a bureaucratic rubber stamp. The entire safeguard structure relies on a human review process that simply cannot occur at the scale the state is operating at.
Having the executive branch, the very government conducting the surveillance, approve and review its own surveillance requests through an impossibly overworked internal committee is like letting a failing student grade their own final exam. Of course they are going to give themselves an A. There is zero independent failure mechanism.
Exactly.
So looking at this broken architecture, what are the concrete reforms proposed by privacy advocates and the CCG report? How do we actually fix the plumbing?
The CCG report outlines several critical structural reforms. First, they recommend fundamentally altering the threshold language. Currently, laws state surveillance can be authorized if it is necessary or expedient. Expedient is a dangerously weak word. It just means the surveillance is convenient, practical, or helpful for the police.
So they want to drop the word.
Yes. The report argues we must strike the word expedient from the statutes entirely. Surveillance must only be authorized when it is absolutely strictly necessary and no other option exists.
Okay, that's one. What else?
Second, they argue for amending Section 69 of the IT Act. We must remove the incredibly broad investigation of any offense ground. We need to return to the strict logic of the Telegraph Act, reserving the devastating power of digital interception solely for severe threats to public order or national security, not routine, local crimes.
And the most important reform, the one that changes who holds the keys.
Judicial authorization. We must completely replace executive authorization, the Home Secretary signing the warrant, with a system requiring prior authorization from an independent judicial magistrate.
Why a judge?
Judges, unlike political appointees or career bureaucrats, offer the best structural guarantees of independence, impartiality, and adherence to constitutional rights. If a police officer has to stand before a judge and mathematically prove the proportionality of wiretap, rather than just getting a rubber stamp from their boss in the executive branch, the number of frivolous, abusive, and disproportionate wiretaps will absolutely plummet.
All right. We have covered an immense amount of ground today. We have traced the evolution of the law from midnight police knocks in the 1960s to automated algorithmic dragnets today. Let's land the plane with a rapid-fire revision summary. You are walking into the exam hall tomorrow morning. What are the core foundational pillars you absolutely need locked in your brain?
Okay, number one, the constitutional pivot.
The
Puttaswamy in 2017 overruled decades of bad law and established privacy as a fundamental right under Article 21. Any restriction on that right must pass the rigorous five-prong proportionality test, though you must note that courts often fail to enforce the necessity prong strictly.
Got it.
Number two, the Old Guard. The Telegraph Act of 1885 governs the transmission of data and demands a very high threshold, the existence of a public emergency or a threat to public safety, as defined in PUCL and tested in Vinita Kumar. The procedural safeguards, including the 60-day limits and the Home Secretary's authorization, are found in Rule 419A. Number three, the digital expansion. The IT Act of 2000 governs computer resources, including stored data. Section 69 allows interception of actual content with drastically lower thresholds than the Telegraph Act, permitting it for the investigation of any offense. Section 69B governs metadata collection, which is arguably even more invasive of a citizen's digital shadow.
Keep going.
Number four, the pragmatic workaround. Section 91 of the CRPC is local law enforcement's favorite tool for obtaining stored retrospective digital records from tech companies without the crippling strict oversight of real-time interception laws.
And the last one.
Number five, the evidentiary battle. While traditional Indian evidence law prioritizes relevance over legality, seen in Puran Mal, the post-Puttaswamy landscape is shifting. Cases like Vinit Kumar now mandate the destruction of evidence obtained through illegal state surveillance to protect vertical privacy and deter unconstitutional police action.
That is the perfect architectural blueprint for acing this topic. You have the mechanics, you understand the case laws, and most importantly, you understand the underlying philosophy driving the courts. But before we let you go, we always like to leave you with something to chew on, something that pushes the boundaries of the notes.
Let's think about the ultimate endgame of this technological arms race. As citizens increasingly realize the staggering extent of state surveillance, they are actively migrating to end-to-end encrypted applications like WhatsApp and Signal to protect their private lives.
Right.
Because the mathematics of true encryption are unbreakable, traditional content interception under Section 69 of the IT Act is rapidly becoming technologically useless. The government can easily tap the wire, but all they intercept is scrambled, unreadable code.
So what happens then?
Well, does the rise of unbreakable mathematical encryption paradoxically force the government's hand? If intelligence agencies can no longer conduct targeted content warrants because the math literally prevents them from reading the letters, are they being structurally pushed to abandon targeted surveillance entirely? Are they being forced to rely almost exclusively on masked dragnet systems like Nitra and the aggressive harvesting of metadata under Section 69B? Wow. Is our desperate pursuit of perfect, unbreakable personal privacy actually pushing the state toward perfect, inescapable mass surveillance?
That is a deeply unsettling paradox to keep you up at night. The stronger we make our individual digital locks, the more the government might just decide to monitor the entire hallway, tracking every single shadow instead of trying to open the doors. We started this deep dive talking about physical wooden doors and shattered glass. But in the digital age, the trespass isn't just invisible. It is baked into the very infrastructure of how we communicate. Thank you for joining us on this exhaustive deep dive into Indian cyber law. We hope we've illuminated the complex, often contradictory mechanics of surveillance, privacy, and evidence. Best of luck on your exam. Remember, anyone can memorize the what of a statute, but truly understanding the why, the historical context, the technical realities, and the judicial philosophy is your ultimate shortcut to mastering the subject. Keep questioning the system, keep looking for the invisible locks, and we will catch you on the next deep dive.